Hi everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to talk about contingency fee agreements in California family law cases. So if you have never heard of a contingency fee agreement, you don't know what it contains, you have basically no idea what I'm talking about, I have a second video on my channel that goes over contingency fee agreements broadly, what they have to contain, the rules in California for them. So basically a more general background than this particular video. Again, in this particular video, I'm talking about contingency fee agreements in California family law cases only. So I will give you a very common situation in family law cases. So let's say that I file for divorce, or my spouse has filed for divorce and served me, and I really want to do this divorce, or I guess if I've been served, I really want to fight this divorce to make sure I get what I'm entitled to, and so on. But the problem is that I don't have any money. Can I sign an agreement with a divorce lawyer that says, I don't have any money now, but I will pay you a percentage, 25%, 50%, whatever, of the property that I recover once the divorce is over, and that will be your payment? Can the lawyer in that situation sign such an agreement in California? And the answer to that question actually depends upon the kind of family law case you're talking about. So the legal standard, I'm going to cite two cases in a second, but the legal standard that kind of roughly covers this is whether or not the lawyer's action in that situation would promote divorce or promote dissolution. And if the answer to that question is yes, in other words, the lawyer has to basically finish the divorce, work on the divorce, push the divorce forward in order to get paid, then the answer to that question is no. In California, there are two cases which I'm going to write down below for you. But those two cases basically say that in California, if the lawyer's payment requires that they promote the divorce, push the divorce through, work to make the divorce a reality, that is void as a matter of public policy. So two cases on that. Number one is a case called Newman. That's actually pretty old. It's a case from 1900, actually, of all things. So the Newman case from the year 1900. There's another case from 1931 that I'm probably going to mispronounce, but it's called Thiessen. I'm going to write it down below for you guys. But the basic idea is that if the lawyer's actions promote divorce, if the lawyer has to make the divorce a reality in order to get paid, the courts in California, or California in general, I guess, does not like that. That is void as a matter of public policy. So, I'm not sure if that kind of makes sense to most people. Most people hear of contingency fee agreements rather, and kind of think, oh, well, yes, I can use that in my divorce case. That would be great. But by law in California, if such a fee agreement requires the lawyer to make the divorce a reality, that type of fee agreement is void as a matter of public policy. And that's the Newman case as well as the Thiessen case that kind of go over that. So promoting divorce, however, if that's the legal standard, the eagle-eyed among you probably would have guessed, okay, well, what happens if the divorce is already done? Let's say the divorce was done years ago, but there's a problem with alimony or there's a problem with child support. Can I use a contingency fee agreement to hire a lawyer to help me collect alimony, do child visitation, child support, that kind of thing? And the answer to that question actually technically is yes. The Newman and the Thiessen case don't cover, that type of situation because the divorce is done already. I'll give you my kind of take on it. In my career, kind of in the north central kind of California sort of area, generally it's going to be pretty hard, I think, to find a lawyer that will take any type of family law case on a contingency basis. There might be, and if you are one of those family law lawyers, leave me a comment, get in touch, kudos to you, I guess. But in general, I think every family lawyer that I've ever run across is going to require an hourly payment. So contingency fee agreements in those situations, at least in my experience, are not real common. Your experience might differ. If you really need a contingency fee lawyer in a child support situation or a spousal support situation, and you can find one, great. But in my experience, they're pretty rare. So hopefully that made sense. To kind of summarize then, contingency fee agreements in California in divorce cases or family law cases, you can't have them if they promote the divorce. Like if the lawyer has to make the divorce a reality in order to get paid, In general, California doesn't do that. It's void. But if the if the lawyer's percentage basically is not determined by pushing through the divorce and making the divorce a reality, you can technically get a contingency fee agreement in those situations. I personally have never met a family law lawyer in California who will do that. So hopefully that all made sense, wasn't too confusing. Go ahead and watch this video again. Yeah, and hopefully you guys liked it. Leave me a comment, subscribe, like, share, all that stuff. And I will talk to you guys next time. Thanks.